Hi, this is Chapter 8. It's the dental hygienist and the patient relationship. So we are going to be describing what your professional obligation is between yourself and the patient. We're going to talk about the difference between civil law and criminal law. We are going to compare what intentional torts and unintentional torts of negligence are. And we are going to be going over the responsibilities of the provider-patient relationship. We're going to state the patient's responsibilities and elements of informed consent and contributory negligence. So what I want to tell you first is I have a handout for you that I think makes the civil law and criminal law part of this discussion a little clearer, where you can differentiate between the different factions. So the patient relationship, critical factor in the delivery of quality care, of course, is the patient. So there has to be a commitment on both parties to do the best, to tell the truth, to comply. So each one of you has a certain expectation, and if expectations aren't met, then there's unhappiness. And so it behooves us to communicate with each other and tell each other our expectations of the appointment. So, or treatment, long planned. So professionals, we have an obligation to also comply with the laws that govern dental hygiene care and meet these standards while doing so. Failure to fulfill the professional obligation can result in bad consequences for the dental hygienist and the patient. So the patient will receive substandard care or unauthorized care. Several possible consequences for that. There can be a complaint investigation done. There can be disciplinary sanctions. They can fine you. They can put you on probation. They can suspend your license or revoke it. There could be criminal penalties and or civil legal action. And there could be, obviously, with all this, a discontinuation of the patient relationship to where they leave your practice and badmouth you. So there could also be, depending on what the infraction was, a loss of your employment. So let's look at the legal framework. Our professional relationship with the patient is legally binding. Okay, so based on societal beliefs of protective rights is how the legal framework kind of is put together. So retribution for harm through civil and criminal litigation is usually how it is solved. And retribution usually means some kind of monetary amount that is paid to the person who believes that they were wronged. So society believes that we all have the right to be protected. And if we come to harm at the hands of another, then we should have the right to be compensated. So we're going to go discuss about the civil offense and a criminal offense. A civil offense is a wrongful act against a person, your privacy, your property, a contract that you have with someone else. These would be civil offenses. A criminal offense is called a violation of societal rule. The societal rule is what says don't kill. It's wrong to kill somebody. It's wrong to steal from somebody. And it's wrong to, commit murder, whatever. Those are all criminal offenses. So a civil action has to do with things that are not taken into criminal courts. They're not criminal, but they are very serious, and you can have a civil action and a civil court for those. So legal action taken to protect the private rights of individuals. Someone trespasses on your property. that will go under civil law, unless they kill somebody on your property, and then it would go under criminal law for murder. And when you have this civil action, there's a plaintiff, and that's the party that's bringing the claim in a civil case. A defendant, who is the party that's defending themselves against the claim. And you have discovery. Discovery is evidence gathered from interrogations and depositions, that those are done out of court. And so the investigators may meet with you, or prosecutors or defenders may meet with you and try to get a deposition from you. So they are going to ask you what your version of the story was, and interrogate you with questions, and that's your deposition that they may bring in to the court case. A trial is a resolution of claims and allegations. So another thing you're going to need to know is what the difference is between a judge and jury. A judge is going to decide the law. A jury decides the facts, and you need to know that. So let's take, for instance, when you're in a court, a judge is reprimanding or approving the lawyers that are talking, right? You've seen it on television. The judge will say whether he upholds what one lawyer is saying, or whether he decides that that's inadmissible to court. So he is constantly judging the law, what it's legal for the attorneys to say, what is not legal for the attorneys to say, what's illegal for them, what laws exist for them to be able to bring in certain kinds of testimony into the court. He is judging pure law. He's not judging the right or wrong of the situation. Who decides the right or wrong of the situation is the jury. Now, they don't reprimand the attorneys for what they are saying or doing. What they are supposed to do is just take all the facts, not what they think might happen. They have to go on the facts only, and they have to take the facts of the case and decide whether the person is guilty or not guilty, or whether they proved their innocence or not. So that the judge decides law, juries decide facts. So in a criminal case, the establishment of guilt requires a high level of certainty. And we've all heard this on television also. It's called beyond a reasonable doubt. You have to just say that we the jury, think this person is guilty beyond a reasonable doubt. But in a civil case, it's different. In a civil case, you have to have a preponderance of evidence. Okay? So in a civil case, the certainty must be greater than 50%. A requirement that more than 50% of the evidence points to something. This is the burden of proof in a civil trial. So the burden of proof in a criminal case is they have to prove that either a wrong happened or it didn't happen beyond a reasonable doubt. And in a civil case, they need to have the burden of proof is a preponderance of evidence. So this is an example of preponderance of evidence. At the end of the civil case, like let's say A versus B, so 51% of the evidence brought about favors group A, case A. Thus, A has the preponderance of evidence. A has met their burden of proof, and A will win the case. It doesn't matter who has the most evidence. It matters whose evidence is more convincing. So, B could have 5 stacks of 3 feet high of evidence, and A could have 1 stack of evidence. Okay? But what's inside all that evidence is that A has proven it's more convincing, even though it's not as much. It's more convincing to the jury, so that's why they win their burden of proof, and that they will win the case. So 51%, and that's how civil cases work. Criminal law. Let's look at criminal law. Criminal law is a violation of societal rule outlined by statutory law, law that is coded according, like I've said in other videos, it's a law that says, law 1, 2, 3, 4, D8 is, Smith versus Jones is maybe, and we'll have a law case around it. And each one of those, what they bring up in that case is actual coded laws with just a plain law. So it's a violation of societal rule because society has decided as a whole that it's best if we all agree to say that murder is wrong and we punish for that. Okay, so society kind of has gotten together and decided what those things are or should be. Physically harming someone with a weapon is a criminal offense, as is practicing dental hygiene without a license. It's a criminal offense. Okay, so both civil and criminal offenses can be committed in the same office or in the same practice of dental hygiene by the dentist or the hygienist. You could create civil and criminal offenses. So let's look at civil law. Civil law is one big category. Civil law, you have civil law and criminal law, and that's it. So underneath civil law, you have two categories. You can have contract law or tort law. Contract law is an agreement to keep a promise. It's a fiduciary relationship, which is a delivery of some type of care for monetary fee. It may be express or implied. So failure would be breach of your contract, okay? And it would be remedied through the judicial system. Someone wrote a contract with you and they didn't fulfill their end of the contract and you paid the fee, or you wouldn't pay the fee, and it's taken into civil law. That would be contract law. We have a contract with our patient. It's a contractual agreement that they come into the office and we're supposed to give them the best of care. So it's nothing that we write out in contracts, but it can be express or implied. Implied meaning that they, obviously, if someone comes into your office for dental, they're coming there for dental care. They're not coming there for an art lesson. So they have to know that that's what they're going to and they're agreeing to put themselves in that situation. Then we are agreeing to go ahead and treat them the best of our ability. So it's implied that that's the reason that they're there. Or you can have an express contract, which maybe they go ahead and sign some kind of express contract. And that would be contract law. If something goes wrong, then it's going to be remedied. They're going to take you to court over that, and it will be a civil course, unless it's murder, which would be a criminal. But I don't hear too much murder in the dental offices except in the movies. So it's going to be something that they're not happy with, or the fee or something like that, and it would be taken to a civil court. So the other type of civil law is tort law. So this covers a civil wrong resulting from breach of legal duty because of what society has as expectations. It's not through a contract. Okay, so what are some examples? You can have an intentional tort and an unintentional tort. An intentional tort is a deliberate and purposeful act against a person or property. That's a tort. It's intentional. You meant to do it. So you meant to steal that property, and you did. You meant to steal your co-worker's handpiece. Okay, and that's an intentional tort. You meant to do it. An unintentional tort, there wasn't any intent to cause harm, but harm does occur. Okay, so in an intentional, you deliberately did it whether you didn't care if it was going to cause harm or not. So let's look some more at intentional torts to persons. They consider battery and assault. You hear it all the time. Usually they'll say it, assault and battery charges. And battery is a harmful, it's non-consensual. You don't agree to get hit or hurt. It's offensive contact with a person. It's physical invasion. And so someone, like you can see in the picture on the PowerPoint, he's attacking this person and they're fighting on the street. Or it could be something where a spouse could take you by the shoulders and plant you, rough you up a little bit and slam you against a wall. Okay, so that's battery. If I just took your arm and shook it and squeezed the half of it to where it was harmful and a contact, that's physical invasion. That's battery. Okay, so putting your hands on a person without their permission in a rough way, a harmful way, is battery. So an assault is causing apprehension. There's no physical contact in assault. Even in sometimes on movies, I hear them and they're kind of using it, an assault, as someone attacked you. But an assault, in fact, is scaring someone. No physical contact, but someone is standing over you, yelling and shouting at you, and maybe you keep backing up against a wall and you're fearful of your safety. That's an assault. They don't touch you, but you're fearful that they're going to by their actions. That's an assault. So misrepresentation would be false representation. That's an intentional tort to persons. When someone would practice without their license because they need the money and it hasn't come from the new state that they that they used to practice in, or they start practicing for someone right after they graduate without their actual license in their hands, that's misrepresentation. You're saying that you're a hygienist and in fact you're not yet. False imprisonment is an intentional tort to person. These people mean to imprison somebody. Emotional distress can be an intentional tort to persons. Slander or libel, resulting in defamation of your reputation or character, is an intentional tort to persons. And these are all held in a civil court unless death is or something like that, and then it would go to a criminal. Physical intrusion without authorization. Like I was saying, that this could be someone coming up and trespassing on your property, or someone comes in and steals things from you, or steals things from you in the clinic or at your office. It's an intentional tort to do that of your property. So this is an unintentional tort to persons. It's considered to be negligence when they say there's a malpractice suit and it's because of negligence. It's unintentional tort of failure to act as a reasonable, prudent person under similar circumstances. So what this is, and you can see by this picture that they did an operation and they left some scissors or whatever. Sometimes they leave things in operations. They took an x-ray and they can see. Now, no one meant to do that. So it's an unintentional tort, but it's a failure of that doctor or doctors to act as reasonable, prudent person under the same circumstances, because we can't just say, oh, that's okay, you made a mistake. They shouldn't be making those kinds of mistakes. So they did not act, and of course were breaching standard of care. So an example of this, of negligence, is malpractice. And that's an unintentional tort. So rights and responsibilities in box 8.1, you can see to where the responsibilities of a dental hygienist when giving oral health care. We need to possess a proper license and registration, comply with all the laws, practice within the scope of practice as dictated by the state law. We need to exercise reasonable skill and judgment and care when we assess, diagnose, and treat patients. We need to use standard drugs and not be trying new drugs on our patients and making them guinea pigs. We need to, the drugs meaning local anesthetics, any kind of new materials or new techniques that might come about. We need to be proficient at those techniques before we just start giving them on our patients. We need to complete treatment within a reasonable time and not have treatment stretch out. What should have been a 4-week treatment stretch out to 4 months. Charge reasonable fees. Never abandon a patient and always arrange for care during your absence. So if you are going, this mainly has to do with a dentist, but a hygienist should never abandon a patient if there's not someone to care for them. If you're going on vacation, you need to make sure that your dentist has a sub in for you to take care of your patients while they're gone. Refer unusual cases to a specialist if they need to be there. Don't try to keep them at your office because you get to have a bonus plan. If they belong somewhere else, you need to make the dentist known know what's going on with that patient. Maintain patient privacy and confidentiality always. Keep accurate records. Give adequate instructions to the patient, and that means verbal and written. Maintain a level of knowledge and practice within the code of ethics. So here's some patient responsibilities. These are responsibilities that really they have toward us. If we're going to give them treatment, then they need to pay a reasonable fee in a reasonable amount of time. So we're trusting when we give them treatment that they are going to be able to pay for it. So they need to cooperate with us in care and keep their appointments. When they say they're going to be there, they need to be there. If it's an 8 o'clock appointment, they need to be there a little before 8. If they can't be there, they need to cancel within time enough to let you be able to put somebody else in there. They need to provide accurate answers about dental or medical history and current health status. So you can't do much to protect their health if they're not going to be honest with you on the health histories. They need to hopefully follow your instructions, including home care instructions. We can clean their teeth. We can give them therapeutic care. We can do everything, give them instructions. But if they go home and they don't do anything about it, then there's not much. We've done our part. There's just not really much we can do about that. It's a duo relationship. So dental hygienist responsibilities. Current licensure for the state of practice. Once again, you must display your license. You do not have to display your driver's license. It's on a quiz that people don't read all the questions over. And so you don't have to display anything. You can display your actual degree, but you must, if you want to or not, but you must display your actual license. So non-renewal or denial of a license renewal, it means that you cannot practice. If for some reason you didn't renew it in time or they denied it for some reason, you can't practice until you get it straightened out. So perform only legally allowed duties with appropriate supervision, and care must be must meet the professional standard, and use professionally recognized drugs, materials, and techniques. Treatment must be completed in a timely manner, like we said. Fees must be usual, customary, and reasonable. Treatment cannot be stopped if harm will result. Abilities and limitations must be understood. Referrals made must be appropriate. We need to respect the patient's right to privacy, and patient's records, accurate pre-treatment and post-treatment must be appropriate. So this just sounds a lot like what was on the previous, just put in a different way. Here we go, legal actions for healthcare injuries. There's 3 most common legal actions. there's a lot of legal actions that can be taken. But the three most common you'll see is substandard. You're giving substandard care. And in that, it's failure to obtain informed consent, professional malpractice, and breach of contract, that you had a contract and did not fulfill it. Those are the three most common, and I would know those. So the American Dental Hygienists Association recognized responsibilities of the hygienist and the patients, but they provide oral health care, high levels of professional knowledge, judgment, and skill. And this is what the American Dental Hygienists Association recognizes as our distinct responsibility. We need to maintain work environments that minimize risk of harm. We need to serve all patients without discrimination, avoid action toward any group or individual that may be interpreted as discriminatory. So we need to hold our professional, means our patient relationships, confidential, communicate with the patients in a respectful manner, promote ethical behavior and high standards of care by all dental hygienists, serve as an advocate for the welfare of patients. We need to provide patients with the information necessary so that they can make an informed decision. So if we don't give them all the information, they're not maybe making the best decision for themselves. About their oral health, we need to encourage their participation in treatment decisions and our goals for them. So we need to refer to other healthcare providers, these patients whose needs are beyond our ability, the dental hygienist's ability or scope of practice. Educate the patients about high quality oral health care. Educate them on what can happen if they go along with what you're saying. Educate your patients on what can happen if they don't go along with what you're saying. So recognize that cultural beliefs influence a patient's decisions quite often. And a case in point, there was a husband and wife that is from a different culture, a culture to where the husband is the leader of the family and makes a decision on everything. So the husband was out in the waiting room and the wife was in as a patient. And as I was checking the patient over, the hygienist and I quickly could see, the student hygienist and I could quickly see that this patient had never had her teeth cleaned. She was maybe, I don't know, late 20s, early 30s. She had a really severe case of periodontal disease. So we were we were explaining to her about the process of SRP. She listened to it and then she stopped us and said she could not make that decision, that her husband was head of the household, and since it was going to cost her $30 at the clinic, she couldn't make that decision, and could we please call her husband in? So we had to turn around and explain everything to him, and he said no. He said no, that wasn't, he didn't think that was necessary for her. Okay, so we have to recognize the cultural decisions and influences that they have and not try to fight that. It was really sad. So, informed consent. Every citizen has the basic right to be free from invasions on their body without permission. So that includes a cleaning or x-rays or an instrument in your patient's mouth. That's an invasion of their body. So we need to have their permission before we are doing things to another person's body. So the ADHA Code of Ethics for Dental Hygienists came in. Individual autonomy and respect for all human beings. People have the right to be treated with respect. They have the right to be informed to informed consent prior to treatment, and they have the right to full disclosure of all relevant information. And when you give them all that, then they can make an informed choice about their care. So our duty to disclose is the nature of the patient's condition or diagnosis. We need to disclose the nature and purpose of our proposed treatment, the risks, the consequences, anticipated results of our treatment, an alternative feasible treatment, risks, consequences, anticipated results of that alternative feasible treatment, and probable or possible consequences of accepting no treatment. And then they can make a decision. Who can give informed consent? Okay, so obviously competent adults that are of age, other authorized persons when the adult is deemed incompetent or incapacitated, a caregiver, guardians of minors, parents or guardians, the age of 18, and that is not always correct. It's the age of the majority is what it's called. In our state, it's 18, but in some states, it could be 17, it could be 19. So it says, what age am I of legal limit? The answer to that question is whatever age your state that you live in says that it is. That's the legal age. So exceptions. Parents who are minors are granted authority. So you have two 17-year-olds or 16-year-olds that are married and they have a child, they have a family already, they are granted authorization to be able to sign their own paperwork. The other group is legally emancipated minors, minors who have gone to court and emancipated themselves from their parents. And if they're legally emancipated, then they may go ahead and sign their own papers. Documenting informed consent. The informed consent does not have to be written to be valid, but unwritten consent is really difficult to prove. My office we did not make anyone sign a document of SRP. So I guess if anyone came back and said, if the patient ever came back and said, well, I didn't agree to this, it's really difficult to prove if you don't have anything written, whether they did or not. It's your word against theirs. It's implied though, because if they're coming to the appointments and they're having SRP and they know that they're getting anesthesia and everything else, and they come back a second time, it's kind of hard for them to prove that they didn't know what was going on. So options for documenting informed consent would be entries in the chart, specific consent document like we have at the school, and electronic consent software that will let you do that electronically to sign documents, like maybe off of an iPad or something in an actual office. Professional malpractice. This began in common law. This began way back in common law. This was a failure to exercise the degree of care, skill, and learning expected of a reasonably prudent oral health care provider in a similar circumstance. Okay, the exception. Some states protect providers against malpractice if they are volunteers. So if your dentist decided to volunteer at a big MOMOM or Team Smile and something happened, then the state may, depending on the state, may protect those providers if one of those people decided to sue them for malpractice for something. Okay, so shared responsibility. A patient healthcare provider. There's something called supervised negligence or contributory negligence. Supervised negligence is more between the patient and healthcare provider. If we know that there is something, we know, like let's say for instance that Infection control is very important, and we know that one of our hygienists or assistants is not providing that service like they should to their patients, and we just don't do anything about it. It's called supervised negligence, that we see it and we're just kind of supervising. As a supervisor, we see it, but we're not doing anything about it. Okay, contributory negligence is exactly what it sounds like. Two people have to contribute to that in order to make that a case. The provider fails to meet the standard of care in some way, and the patient fails to comply with the treatment plan. So that would be and where this would come into play in private practice, these SRPs can be 1,000, give or take. So let's say that it was $1,200 for them to have their SRP. And so after it was finished, after it was completed and they healed for the month and they came back, nothing had changed, and not much had changed. And you could tell the tissue was in terrible shape. They could tell you all they wanted to that they flossed in the correct way and that they brushed all the time, and if their health history doesn't prove that their gum tissue should be in a poor way because of any illness or drugs, then you look to them and you're like, there's no way that you really believe that. You can't say that, but you are not, you know that they did not comply with the treatment plan and didn't do what they were supposed to do, or they let, a month go by or 2 months go by before they even came back to see if their evaluation. They're not complying with the treatment plan at all. They don't show up for their appointments, a couple of them, you have to reschedule, you're not on time. That's contributory negligence. But it would have to be proved that both things, that you somehow failed to meet the standard of care and that they failed to comply with treatment. So there is something between the hygienist and dentist that's called, and also the assistant or anyone else in the dentist's practice. It's called respondeat superior, and you will need to know that. What it means is that employers can act through their employees. That's what it actually, how it's stated. What it means is it actually might be the other way around. Employees can act through their employers, because what it means is that the dentist is really, we're working under their license, and what we're doing, and that they know they have to answer for what we're doing also. So they have to take liability for most of this stuff. Now, we could have to do it too, but a lot of times if things go to court, they'll just want the dentist there, and you may be called or not to go in with the dentist. It all depends on what the infraction is. Statute of Limitations. There's limits on the period within which an injured party can file a legal action, and that's different. It varies from state to state, so you have to check your state laws. Typically, though, it's 2 to 4 years from the date of the alleged act, omission, or neglect. So because you're doing something and give an SRP to someone today, it could be maybe you gave them some tissue trauma, or they never really came out of the paresthesia from an injection or something, and so they could wait 2 years after the actual incident and then try to have a case in court against you for what they consider that you did or neglected to do, or some omission or act that you had. It has to be between 2 and 4 years from the date of the alleged act. If it's more than that, then it's a moot point. They won't take the case. So reported to the State Health Profession Regulatory Board. These are some reporting requirements. like in Arizona and Oklahoma, they would want this reported to the State Health Profession Regulatory Board. There's a national practitioner data bank which collects and discloses negative information on healthcare practitioners. You can report some of the reports, and you can find those out. So breach of contract is the most common of the three that we talked about, that were the three common breaches or complaints that they find at the state level that people are complaining about with a dental care. And the most common of those is breach of contract, a promise that injury would not occur. And this is another reason that we definitely don't say when we give an injection, now you'll be free of any pain, because they may be feeling pain. They're definitely going to feel a little bit of pain when the needle goes in. It's just a pinch, but it still is. So we don't make promises that we can't keep. You know, if in private practice, if you spend $1,200 getting, whether you have insurance or not, getting this done to your SRP done, it's going to give you a healthy mouth. We don't say that, because it may not. And part of it's dependent upon how they can take care of it at home. So we don't make promises we can't keep, and then we don't have to worry about a breach of contract. So I'll let you read through this summary. What I would say is that legal counsel should be sought when specific issues of concern arise. And I'll let you go through this summary, and that pretty much takes care of this chapter. And I want you to be able to take that handout that I wrote up, so that when you study, you can study how there's two kinds of law. And you can civil and criminal, and under civil you have contract law and tort law, and what makes each happen. So you're going to need to kind of pull from that for future questions. So that's what I would do. And once again, as always, if you have any questions about anything or need tutoring or further explanation or examples, you can always read through your book, or you can always email me.